welcomes you, and we are privileged to have you here, sir, for this session. Prem Kumar Agarwal, sir, will speak on international IPR regime and challenges of India, particularly in the context of India. What is the situation here we have? He will be discussing that topic, that only. Let me give you a brief introduction about Dr. Prem Kumar Agarwal. He is an alumnus of St. Xavier's School and College. He pursued his LLB, LLM, PhD from the University of Burdwan, West Bengal. He is a former judge under the judicature of Honorable Calcutta High Court and founder faculty of National University of Juridical Sciences, Kolkata. Dr. Agarwal is presently serving as the head of the postgraduate department of law section in the Heritage Institution of Hooghly Mohsin College, University of Burdwan. As a PhD guide, Dr. Agarwal has been supervising research scholars in Burdwan universities and other universities. He is a strong advocate of human rights and civil liberties. He visited Sweden as a cultural ambassador and delivered a series of lectures on culture, polity, and legal system of India under the prestigious group study exchange program of Rotary International. A past district Rotaract representative, Dr. Agarwal has addressed various youth conventions in Singapore, London, and Paris, besides many places in India. Dr. Agarwal is a PDRCC RI District 3240 and past president of Rotary Club of Burdwan South. Now, apart from that, Sir is the editor-in-chief of Global Journal of Juridical Sciences. Besides being a regular contributor in reputed journals, Dr. Agarwal is a visiting faculty and trainer at the National Judicial Academy of the Honorable Supreme Court of India, West Bengal Judicial Academy of the Honorable Calcutta High Court, Administrative Academy and Police Academy. He authored many books which includes Law of Limitation and Prescription, Intellectual Property Rights of Farmers, Drafting, Pleading and Convincing, Company Law, Decoding the Code, Cases and Materials on the Law of Limitation and Prescription, Law of Adoption, Empowerment of Women, Human Rights Perspectives, Patenting Microorganisms and Genes, and West Bengal Land Laws. Apart from his books, he contributed regularly on reputed national and international journals. We welcome you, sir, again. Now, our head of the institution, Dr. Sunil George, will be welcoming sir. Sir, over to you, sir.
Thank you, Indranath, sir. Prem Kumar Agarwal, sir, good afternoon, and we are very happy to have you here. We are really thankful to you for accepting our invitation and agreeing to chair this session. We look forward for a wonderful session, and once again, welcome on behalf of Amity Law School, sir.
Thank you, Dr. George. Thank you, Professor Adhikari, Professor Sinha, and my dear Indra. It's my pleasure to be in your campus and trying to give some food for thought for my colleagues on a very relevant subject, which is intellectual property rights, and which is very close to my heart academically. So, should I begin?
Yes, sir.
Indra, will you share the slides for me?
Yes, sir.
So, the first slide, please.
Sir, is it visible?
Yeah, visible. Slide number 3. So, yes.
3. Okay.
Yeah. Do you have to
Is it visible, sir?
Yeah, visible. It's visible. So, I would like to start with the basic understanding of intellectual property right. Property, as defined by Salmon, is a bundle of rights. We all know that. Bundle of rights which are exercisable over a resource capable of satisfying human wants. And when the resource over which the rights are exercised the resource is tangible, the property is called tangible property. And when the resource is intangible, the property is intangible. So all the intellectual property rights are intangible rights because the resource over which the rights are exercised are intangible. And therefore, intellectual property rights, be they patents, copyrights, trademarks, designs, or any other intellectual property right, they are all intangible property. Now, intellect. What is intellect? Intellectual property right can be created only by intellect as opposed to manual labor. So intellect denotes one's ability to create something with the help of his art, skill, and research. And property can be defined as highest right a man can have to anything, being that right which one has to lands or tenements, etc., and which is not dependent upon others. This is the definition given by the Honorable Supreme Court in R.C. Cooper's case. Thus, intellectual property is that property where the right of ownership accrues from one's own creation using his intellect. Though it's an intangible property, it needs transformation into a tangible form for protection. Intellectual property must take or manifest in some material form in order to enable its protection. Say, I have a brilliant idea of making a cinema. I share the idea with Indro, and before I can make the cinema, Indro makes it. Now, do I have any remedy against Indro? Because unless the idea manifests in some material form, in this case, I cannot exercise my intellectual property, be it copyright, be it performance rights, whatever it may be. Although it's an intangible property, it needs transformation into a tangible form. Now, all intellectual property laws are national in nature. So, if you get a protection over your patent, copyright, trademark, whatever, it's confined to the national boundaries. An exclusive right is granted for a certain period of time or specific period of time. Like for patents, it is 20 years. For copyright, it is author's age plus 60 years and the like. Now, what is the purpose of intellectual property? The purpose is twofold. It is rewarding the creator, that is the individual interest, and taking care of the social interest. So, why should law allow monopoly to an inventor or a creator? Because monopoly per se is bad. But then the kind of monopoly which is allowed in IP laws is a restrictive monopoly to incentivize the creator or the inventor. It is sort of a trade-off between his disclosing the know-how and the state or the society providing him a right of monopolistic exploitation of the fruit of his creation for a limited period of time. At the same time, taking care of the social interest. Now, how is social interest taken care of by intellectual property? When this knowledge, which has been created by an individual, is kept to himself and he dies with the knowledge doesn't get institutionalized. And this is the story of ancient India. In our country, we had wise men, seers and sages, who had in-depth knowledge about healing techniques of many diseases, for example. But since we did not have a knowledge management system, they died with their knowledge, and the society was deprived of institutionalization of that knowledge. So the intellectual property system, it enables knowledge management in an effective manner. And we are now in the knowledge age, in the knowledge economy. So we are no more in the brick and mortar economy. We are in the knowledge economy. Next slide. So the significance, as we were discussing, to reward effort and recognize creative contribution, to create intellectual wealth, to identify, protect, and exploit potentially valuable creative work, to create a better understanding of the various legal rights for the protection of creative efforts, to increase the involvement of the human resources in research and induce them towards being more and more creative, to ensure knowledge management in knowledge economy, to develop the society at large and enhance the meaning of life of an individual. So if we fundamentally analyze the mechanism or the jurisprudence behind intellectual property through an example, say patent, it is actually a symbiotic relationship, a contractual relationship between the inventor and the state, in which the consideration which flows from the inventor to the state is the disclosure of the know-how, and the consideration which flows from the state to the inventor is enabling him monopoly exploitation of the fruit of his creation for 20 years, after which the knowledge comes into the public domain. So it is a symbiotic relationship. It is win-win situation for both. But then there are other challenges which we'll discuss shortly. Next slide, please. Next slide.
Sir, is it visible? This one, glimpses of international.
No, I am seeing only significance.
No, sir.
Next one.
So we can see glimpse of international protection, sir.
But I cannot see it on my laptop. Anyway, yeah, it's now it's okay.
Okay.
Glimpse of international protection. So since our topic is international IP regime and challenges for India, the way ahead. So let us just go through chronologically the various international conventions on intellectual property rights. It started from 1883 with Paris Convention. Then we had Berne Convention, Madrid Agreement, Hague Agreement, Nice Agreement, Lisbon Agreement, Rome Convention, Locarno Agreement, Patent Cooperation Treaty 1970, Convention for the Protection of Producers of Phonograms against unauthorized duplication of their phonograms 1971, Vienna Agreement, Budapest Treaty, Brussels Convention, Films Registry Treaty, TRIPS 1994, which is the most important one now, Singapore Treaty on the Law of Trademark, WIPO Copyright Treaty 1996, WIPO Performances and Phonograms Treaty 1996. So this is the international regime in the form of conventions. Now, next slide. National protection. Yeah. National protection. It is not visible on my screen. Anyway.
Sir, it's little time on your part.
Oh, yes. It takes little time. Okay.
Yes. Thank you, sir.
So the national protection can be summarized as patent protection, copyright, trademark, trade secret, design, geographical indication, plant variety protection, traditional knowledge, semiconductor integrated circuits, layout design. Now, these are the areas in which we already have legislations by the Government of India. Now, the laws which are there in the municipal legal system, they are being amended to a large extent to make them compliant with the international conventions, especially TRIPS. So the Patent Act was amended quite a few times, and finally in 2005 to make it compliant with TRIPS 1994. And after that, what are the challenges we are facing, we'll discuss. I am yet to see the national protection slide. That is slide number
6.
Yeah, it is not.
So we can all
being
see
shown
this
in-
slide.
Anyway, you can see, then it's okay. No problem. So I'm going to slide number 7.
Sir. Is it visible?
IP regime?
Visible
No,
to you?
not visible in my laptop. Anyway, I can carry on, no problem. I have a separate setup from where I can see. If you can see, it's okay. It's slide number 7. Okay.
Yes, sir. Yes, sir.
IP regime in India. Now, as India is a party to almost all international instruments, the legislature has been framing the intellectual property legislations in compliance with those instruments. As I told you, that the Patent Act 1970 has been amended to make it compliant with the WTO, that is TRIPS agreement. Being a developing country, the fact cannot be denied that it was not easy for India to adopt all the international instruments to make the country at par with other developed countries. However, the transition period is worthy to note. On the other hand, it was needed occasion to harmonize all the national IP laws. After TRIPS, India has tried to be at par with TRIPS agreement, and the vital amendment has been done. It was not easy to adopt all the provisions of TRIPS for a developing country like India. There is always a know-how and knowledge gap in between developed and developing countries. Thus, how much the one provision for all, I have put it in red. Thus, how much the one provision for all is fair is a question of research itself. You cannot paint the entire world with the same brush. Because see, this developed world and the developing world have different interests, different considerations. So you cannot sort of have the same provision for all. That is a big challenge for the entire world, the tussle between the needs of the developed world and the developing world. Now, before proceeding further, let me draw your attention to one thing. Why did this intellectual property rights regime become so popular and occupied center stage in law, in economics, and in everything? Because it is only through the mechanism of intellectual property right the leveraging of income is possible. To put it in layman's words, if you want to become rich, infinitely rich, within a very short span of time, it is only through intellectual properties you can do so. For example, the person who was the richest person on the face of the globe about 20 years ago was the Sultan of Brunei. If you go through the portfolio of Sultan of Brunei, you will find all tangible property, islands, oil wells, gems, jewelries, and things like that. But if you go through the portfolio of the richest person on the face of the globe, one of the richest person, that is Bill Gates, you will find copyrights, in some cases patents for computer softwares. Now, what is the magic in these IPRs which can make a person infinitely rich within a very short span of time? That is the catch. If we try to depict this with the help of a linear equation, now when I am framing the equation, I don't claim myself to be an expert in mathematics or economics. It is just the thought of a layman. If we say I, which stands for income, is equal to T, which stands for time, into rate R. So the income which you earn is the product of the time you spend at the rate at which you earn. So if you want to move I to the power n, you'll have to move T to the power n. Now, how can you move t to the power n? Because you have only 24 hours in a single day. But through IPR, it is possible because other people's work for you. They work for their own interest, but you get richer at their cost. Say, for example, the entire world is using Microsoft softwares, and while using them for their own purpose, they are dropping some cents, some dollars in the kitty of Bill Gates. See, 1 billion people all over the world are using the Microsoft software. You know, $1 billion maybe, for example, is being dropped in the kitty of Bill Gates. That's why he has become so rich within such a short span of time. This is precisely the rationale of the IPR becoming so popular in the last, say, 20, 30 years or 2-3 decades. So, but then it definitely brings in what is known as the gap in income distribution. The developed countries have their own considerations, and the developing world has a different consideration. So the same provision cannot be applicable and cannot be fair for the entire world, and that is one of the biggest challenges. Next slide, please. Now, if we look at these statistics, the source of which is the Parliamentary Standing Committee report in 2021. If you see the number of IP applications from 1516 to 1920, you will find that in India, the filing of or application for registration of intellectual property rights, it is a combined thing for patent, copyright, trademark, everything. Out of the applicants, the increase is basically due to non-resident applicants. So compared to other nations, India stands way behind when it comes to management, enforcement, and filing of different IP. So these statistics show that we are far behind in creating awareness about intellectual property. Next slide, please. It will make more clear. Patent and trademark filing statistics. The first table is regarding patents and the next one is regarding trademarks. So in patent, if you compare the figures of China, US and India, in 2016, the total grants in China were 4,04,208. In US, 3,03,049. And in India, it is 9,847. Not even comparable. In 2019, India, 24,934, whereas US, 3,54,430, and just see China, 4,52,804. This is regarding patent. So if you compare India, China and US, see China is leading the world now. And if you see the trademarks filing, in China it is 64,05,840. In US it is 3,20,562. In India it is 2,94,172. Now this filing of trademarks or granting of trademarks, it speaks volume. volumes of the increase in commercial activity of a country, because trademark is obtained by the businessman or the trader or the manufacturer for exclusivity of his goods or service in the marketplace. So that is a direct correlation with the increase of business or commercial activity in the country. So we can see the dismal picture from the statistics regarding India. Now we'll try to analyze the reasons. Next slide. Now, possible reasons for this lagging. Lack of R&D in India. Research and development plays the pivotal role in fostering research activities and upholding IPR portfolios. These areas should always be in consideration of the government. However, it is disappointing to state that India spends only 0.7% of its GDP on R&D. It is, the source is also Parliamentary Standing Committee report in 2021, which is significantly less than the nations which have large coverage on IPR. So obviously, lack of investment is one of the reasons. An inventor needs monetary support to invent, which is different from incentive. Incentive is the reward, but prior to this, an individual needs support. Thus, the trend is to tie up with some R&D or academic institution. But as the state of R&D is already depicted, same with higher academic institutions irrespective of government or private institutions. Compared to US, EU, Indian institutions are running short of funds. Moreover, the concept of intellectual property financing is in very infant stage in India, which can track and trace and formulate the financing in appropriate manner, intellectual management and valuation. So we are at a very infant stage in this front, and that's why the dismal picture of filing for IPRs, which the statistics showed. Next. Another reason is lack of awareness. Another significant reason is the negligible knowledge in every area. Today, the world is driven by science and technology, and the Western countries are doing their best to take it on another level. Necessary fund, R&D, tools and techniques are in their support, whereas India, as a developing nation, struggles in every such aspects which can foster the innovation and invention, starting from fund to education, technological know-how. However, India is rich enough in human and cultural resources. What it needs is that a friendly atmosphere, which includes IP awareness also. Small businessmen, tribal people of remote areas are not at all familiar with the concept of IPR. Let me share a story with you in this juncture or at this juncture. Actually, when I was at that time in the early 90s, for some time, in my post GSC tour, I stayed for some time in London, and in my host family, I went to the kitchen to prepare some tea for me, and I picked up the container containing tea because it was written Darjeeling tea. So I thought of having some Darjeeling tea in the morning, and when I turned the container, below it was written made in China. So that was in 1997 or 1996. Now, see, the name Darjeeling tea is used by a manufacturer of tea in China. Now, if we use the same name for any other product, say Scotch whiskey or for French wine, and made in India, we will be made to feel the music. But since our tea growers, our farmers, our industry was not aware of the geographical indication, they could easily be duped of their due. But now we already have the Geographical Indication of Goods Act in force. But I'm talking about the 90s. So lack of awareness, one example, which I shared with you. Next. Lack of sufficient encouragement on starting MSMEs and other like fields. MSME and alike fields, including agriculture, is the upcoming IP hub, which should be manifested in a conducive manner. There is a tremendous insufficiency in encouraging these sectors. Now, the critical legislations which are required, considering the socio-economic conditions, India has to consider the legislation relating to the IP laws very cautiously. Intellectual property or IP has got two purposes. One is to incentivize the creator or the inventor, and on the other hand, benefit and development of the society. That is private interest versus public interest. In the process of strengthening IP, the public interest, the ultimate object is not to be diluted. Now, this is the real challenge for the developing countries like India. We'll discuss more of that in the next slides. Okay. Lack of sufficient encouragement on starting MSMEs and other like fields. Oh, we finished this. Yes. Lack of management and enforcement. Non-efficient management and enforcement is the direct consequence of the lack of awareness. IP valuation is a serious matter of concern. These intangible assets, many a times, either because of holders' negligence or the fear of risk of the financial institution, loosen down. Today in the digital era, counterfeiting, infringement, piracy is exuberant. So proper management and enforcement is also a very big challenge in a country like India. One example could be the intellectual property rights in the area of copyright. You can see rampant copying of costly books by the photocopying centers, and the sale of those books, just like original books, is rampant. So these are some big challenges. Challenges need to be focused. So the first and foremost of the challenge which we will discuss today in a little detail is software patenting. Now, when we were intellectual property rights students, a question was thrown to us, and which seemed to be a paradox. Which was the question? For software, we have copyright protection. And copyright protection means the duration is author's age plus 60 years, a rather long term of protection. But the US IT industry, NASCOM, or the Indian IT industry, they are all demanding patent protection, which is only for 20 years. Now, why do they want to forego a protection for such a long period, that is author's age plus 60 years, for only 20 years of patent protection? The reason, at that point of time, we had to think, and then ultimately we could fathom and reply, what could be the reason? Do we have participants in today's presentation? Can we have interaction now, Indro? Is it possible to have interaction now or at the end?
At the end, sir, we have a question answer session.
Okay. So, the software patenting challenge, the Patent Act 1970 governed the law pertaining to patent in India, according to which the threshold of novelty, utility, inventive steps, should be maintained in order to grant patent and must be patentable subject matter in conformity with Section 3 of the Patent Act. Now, the second criteria, that is being a patentable subject matter, somehow works as a limitation or restrictions on granting patent. The situation in US is totally different. In US, anything under the sun is patentable now. We all know that. The patent law is much more flexible in US. Even discoveries are also under the protection of patent by construction. One instance of the non-patentable subject matter is software. Today, the whole world is driven by technology, especially the digital economy. Estimates suggest that the digital economy, which relies heavily on software-related innovations, already represents 22.5% of the global economy. According to Gartner's estimates, IT spending in India is estimated to reach US dollars 93 billion in 2021, 7.3 year-on-year growth, and further increase to US dollars 98.5 billion in 2022. Indian software product industry is expected to reach US dollars 100 billion by 2025. Is this slide visible for you? Slide number 15.
Yes, sir.
Okay.
Law of patent, software patenting.
Yes, in my laptop it is not visible. Anyway, I can carry on.
The participants can see it, sir.
Yeah, okay, no problem. Continue. So, slide number 16. Mainly, sir. Yes. Mainly, software is capable of being protected under patent law, copyright and trade secret. In India, software is being patented under copyright law. However, history has evidence to show that patent law offers the most effective framework for protecting an invention's functionality. Now, I'm quoting the WIPO. While the advantage of copyright is that protection is automatic and free of charge as long as work is original, reliance on copyright as a sole protection system only safeguards against the literal copying of the source or object code. It does not protect the underlying invention implemented by the software. The question which I was asking for interaction has been answered by WIPO in this sentence. Keep this at the back of your mind. Moreover, copyright will come into picture when there is an unauthorized use. Thus, protecting software by copyright in the digital era is not efficient. Patent in this respect will not only protect from infringement, but also provide stronger mechanism to stop infringement. With respect to the protection under trade secret, in India, the only protection we have is the non-disclosure agreement. Over and above, there is no systematic legislation on trade secret in India. So commercialization under trade secret is a bit risky. Moreover, trade secret protection is not appropriate for standardized technologies that facilitate interoperability, such as smartphone communications technology, because standard setting organizations require the non-confidential exchange of technical information, WIPO added. And therefore, this protection through trade secret or protection through copyright, mere protection through copyright is not enough. On the other hand, patenting software has got some remarkable benefits. Ensuring inventors get a reasonable return on their commercially successful innovations, making it easier for innovation-based startups and small businesses to establish fruitful business collaborations. So it will incentivize small businesses and startups if we have patent protection for copyright or patent protection for softwares. Promoting the systematic sharing of knowledge through patent disclosure itself an important driver of innovation, which I just now said, helping attract investment partners and support business expansion. In US and EU, that is European Union, software is eligible to be patented subject to certain conditions. In India, who is the culprit? Section 3K of the Patent Act 1970, which simply prohibits patenting software, which includes a mathematical or business method or a computer program per se or algorithms. They are not patentable. However, there is a changing dimension with respect to Section 3K of the Patents Act 1970. A joint parliamentary committee report 2001 have highlighted the proposed changes as follows. Sometimes the computer program may include certain other things ancillary thereto or developed thereon. The intention here is not to reject them from grant of patent if they are inventions. However, the computer programs as such are not intended to be granted patent. The latest guidelines for examination of computer-related inventions, that is the CRIs, which pertain to patentability of computer programs, including software, provide further clarity in this regard. Although the 2019 Manual of Patent Office Practice and Procedure did not clarify the position. Although a ray of light can be seen by noting here that Indian patent has been granted for software programs like Google's location history filtering patent, Oracle International Corporation's a system and method of preparing compended blogs, Microsoft Corporation's disaggregated secure execution environment. Now let us come to pharma patent and challenges.
Sir, slide number 21.
20.
20, okay. Pharma patent.
Pharma patent and challenges. This is the area where both the human rights stands in conflict with each other. Right to health and public access of medicine and right to develop and invent. At this juncture, it should be noted that there was an aggressive push for the TRIPS by the developed countries, especially the United States, backed by its pharmaceutical transnational corporations. These countries considered that higher cross-border IP protection, which could be effectively monitored through a multilateral agreement, would bring in greater rents for their pharmaceutical corporations. On the other hand, developing countries were not keen on an agreement on IP in the WTO. Before TRIPS, Indian Patent Act 1970 did not have the product patent in pharma and agrochemical. Thus, the pharma industry was much affluent, and public access to medicine was not a concern. However, with compliance to TRIPS and to develop the patented drug industry in India, product patent was introduced with restrictions. So, what are the challenges now? Section 3D of the Patents Act 1970 says, the mere discovery of a new form of a known substance, which does not result in the enhancement of the known efficacy of that substance, or the mere discovery of any new property or new use for a known substance, or of the mere use of a known process, machine or apparatus, unless such known process results in a new product or employs at least one new reactant, is not patentable. After pharma product got the protection of patent, the struggle between right to access medicine at an affordable price and right to intellectual property was realized, which led to Doha Declaration in 2001, which tries make flexible the terms of the TRIPS with respect to public health. It allows compulsory licenses along with export and import at an affordable price. Initially, Article 31F of the TRIPS did not say about export, which led to complicacy to the developing and underdeveloped nations. This problem was recognized in Doha Declaration, and TRIPS was amended in 2005 and got effected from 2017. Now, this also does not solve the problem. The first step to issue compulsory licenses by developing country is not always possible, where there exists a continuous pressure from developing countries. Considering the protection of intellectual property and compulsory license, the picture of COVID-19 vaccine is not unambiguous. India and South Africa, backed by many developing countries, want a temporary waiver of IP rights on COVID-19 vaccines, as well as diagnostics, therapeutics, and medical devices. They argue that scrapping these protections will enable poorer countries to manufacture more vaccines, treatments, diagnostics, and other vital medical tools needed to battle the coronavirus and address the extreme inequity in access to vaccines. In their proposal, India and South Africa identified the unworkable nature of Article 31 bis to address the challenges posed by COVID-19, given that a large number of countries lack manufacturing capability in the pharmaceutical sector and that they would need COVID-19 vaccines for their population. The lengthy and cumbersome procedures listed in Article 31 bis would only hobble their efforts at universal inoculation. Following the procedures listed in Article 31 bis for a large number of countries simultaneously would severely slow down the export of vaccines, thus proving to be costly when countries need these products urgently amid a pandemic. Therefore, the sheer scale of the problem and colossal demand for vaccines from all countries of the world make the TRIPS flexibility impracticable. See, so these priorities of the developed world and developing worlds are different. And this was clearly exposed in this pandemic. The priority of a developing world, the poor countries, they need to emphasize more on the welfare state concept. Whereas the developed world, they are taking the side of their MNCs, their manufacturers, for strengthening the IPR regime. And this is a long tussle which is going on in the world, which is the very big challenge for the developing world. However, the pharmaceutical industry and many high-income nations fiercely oppose the proposal, saying patents are not the main obstacle to scaling up production. One of the chief concerns about IP waivers is that they could give a shortcut to competitors. This is the stand of the developed nations. Now, try to understand this figure. Seeking to acquire expensive technology, companies also argue that IP relief will not accelerate vaccine manufacturing because materials are scarce and it can take years to build up capacity from scratch. So the tussle started since TRIPS came into being and probably has no end. You see, policymakers' priorities is the IPR regime, affordable medicines, accessible healthcare, and high profits, consistent return on investment to shareholders, sustainable growth. So it is a tug of war between high profits, consistent return on investment to shareholders, and on the other hand, affordable medicines and accessible healthcare. We all are aware of the landmark judgment by the Supreme Court ultimately in Novartis versus Union of India, where the entire country was faced with this challenge. Now, non-existence of data exclusivity. It will be existence, mind you. Sorry for this spelling mistake. Another aspect of challenge with respect to compulsory license is that India does not have data exclusivity protection. Thus, while using section 107 of the generic company are experimenting to reach the generic drug within 20 years of patent protection of a patented drug, so that evergreening will be stopped. The interest of patent holder is jeopardized because the patent holder cannot exclusively enjoy his monopoly rights while section 107 is being invoked. This has a direct consequence with lower rate of patent filing in India. So this is with respect to the section 107 of the Indian Patents Act 1970. Now, AI, artificial intelligence and intellectual property. Artificial intelligence is the new morning which will lead any industry in a couple of years. The benefit of technology is huge. However, to manifest it properly, legal protection is needed. With respect to the intellectual property rights in the industry driven by AI, it neither needs patent or copyright. It either needs patent or copyright protection. However, trademark and AI is also an important aspect to be considered. Now, this figure depicts for the entire world the patented inventions, which is, see, it is increasing every year. It is for the whole world. But Indian Patent Act 1970 as well as Copyright Act 1957 is not equipped to manage the creation relating to artificial intelligence. Why? As discussed earlier, Section 3K of the Indian Patent Act 1970 prohibits the patenting on mathematical or business method or a computer program per se or algorithms. Recently, the report of Parliamentary Standing Committee estimated that the benefits from AI-related innovations, if drawn in an optimal manner, would add US $957 billion by 2035 to the Indian economy. Therefore, in order to extract benefits from AI, revisiting of IPR legislations and implementing a strong intellectual property right framework is desirable. Now, the impact of automation could in fact be more disruptive in lower wage developing countries, where manufacturing employs a large proportion of the workforce than it does in developed countries. However, it has been reported in the WIPO technology trends, Artificial Intelligence 2019, that India is emerging as a new target for patent filing. So this figure depicts in bar chart the patent filing by different countries. India is here. This is slide number 28.
Sir, yes, sir.
Yeah. India ranks third in fuzzy logic and fourth in machine learning, whereas it is eighth or lower in patenting activity. However, unlike in patents, India is highly ranked for scientific publications in almost all functional applications. It is source is WIPO 2019 report. Also in March 2018, India launched a plan to have enabling policies for socially relevant projects, especially a data policy to include ownership, sharing rights, and usage policies, as well as tax incentives for income generated through the adoption of AI technologies and applications. This was followed by a discussion paper, National Strategy for AI, in June 2018, recommending a data protection framework, sectoral regulatory guidelines, and the creation of open platforms for learning. The US Patent Office has the most controlled method patent filings, while China leads in patent applications in distributed AI, planning and scheduling, predictive analytics, and robotics. In India, we do not have any legislation as of now. Challenges in copyright regime. Section 31D was introduced into the Indian Copyright Act 1957 in the year 2012. This section was introduced in compliance with Article 11, Clause 2 and 134 of the Berne Convention, Article 9.1 of the TRIPS Agreement and Article 15.2 of the Rome Convention for sound recording, and deals with statutory licensing for broadcasting of literary and musical works and sound recordings. Article 31D of the Act, read with Rules 29 and 30 of the Copyright Rules 2013, enables broadcasting organizations to broadcast or perform any literary or musical works and sound recordings by issuing a prior notice of such intention to broadcast the said works and by paying royalty to the right holders as fixed by intellectual property right appellate boards. However, it does not include internet broadcasting, because of which India is facing challenges with respect to licensing in the digital era. So we have these two case references since we do not have any law on internet broadcasting. So case reference is Tips Industries Limited versus Wink Music Limited and others, Warner Chappell Music Limited versus Spotify AB. These are most only unreported cases. We did not find the citation. Now, so what is the way ahead? Because we began, our topic contained this last phrase, challenges, way ahead. A new parliamentary standing committee report is definitely a welcome step. However, it has proposed to revisit the IP regime in India, out of which section 3B, 3J, 3K is much debatable. On the one hand, India needs to upgrade its position in intellectual property rights, and on the other hand, the socio-economic and cultural perspective should be taken care of. This is a tough challenge for India, no doubt about it. The quality and the quantity of the intellectual property should be maintained. For the purpose of increasing quantity, how much the quality is to be compromised is a matter to be determined cautiously. There is an utmost need to increase funding in establishing research and development and academic institutions, which will in consequence attract foreign investment. IP financing is in its infant stage, which should be popularized as early as possible in the widest manner, and proper legislative framework is highly recommended. There is a need to recheck the law relating to IPR because many of the aspects are not being dealt with yet. However, what the Standing Committee report suggests need a conducive environment to become reality. Trade secrets should be given a structural framework, which we don't have. Traditional knowledge and biodiversity of India should be protected. Only the black letter of law cannot help it. A proper administration is desirable. We are not even aware of the traditional knowledge or the extent of traditional knowledge which we own. A mere law is not sufficient. IP awareness and enforcement mechanism should be strengthened in order to curtail counterfeiting, piracy, and to attract the foreign investors. SMEs should be encouraged in different ways by tax rebating. These are some of the suggestions for way ahead regarding the misuse or the piracy of traditional knowledge by the pharmaceutical industry. If you want to have some idea of it, you can go through one of my chapters in my book, Intellectual Property Rights of Farmers, where I have worked out the economics of the biopiracy or the piracy of traditional knowledge from India by the pharmaceutical giants of the world, where it is proved that the economics of all the theft of traditional knowledge in some part of the manufacturing process of a pharmaceutical allopathic drug works out to be 100 times the entire IT industry of the world. Just try to fathom the extent of the theft of traditional knowledge from India and the other gene-rich South. Thank you for the opportunity, and if we can have some interaction, it is welcome. Although
Yes,
I do not claim to be an expert in intellectual property, but then if I have created some thoughts in your mind, it is a food for thought for my colleagues. Thank you. Yes, Indra.
Thank you, sir. Thank you so much. Yes, participants, you can put questions. Any questions from any of the participants? Yes, any questions? Okay, fine. No question is there in the chat box. Sir, I have a question. Like, what is the stand of these in space law? Like, for space law, is it required to have patents or this means intellectual property rights? How it is linked, space law and IPR laws? Because as we know, ISRO or like our satellite programs are quite successful compared to other streams. So how will?
Yes, definitely. In space law also, we can invoke intellectual property laws. And actually, if it is say some technology which we are using in the space missions, that can be definitely protected by the intellectual property right laws through patents and through other laws. But then the double standard of the US is a problem there. But then in space law, yes, there is a scope of applying intellectual property rights.
Okay. Thank you so much, sir. Thank you. It seems to me that I'm again sitting in your class after a long time. I got the opportunity. So thank you so much. Yes, so over to Mononita, madam. Okay, there is one question. So what is your take on abolition of IPAB? Abolition of IPAB. Yes, a question from Vastoranjan.
What is IPAB? What is AB by?
Abolition of IPAB. Yes, can you, yes, Mr. Ranjan, can you please put the full form of IPAB? Hello. Intellectual Property Appellate Tribunal, yes.
Oh, appellate tribunal. That is IPAT, appellate tribunal.
Yes, Appellate Tribunal. It must be T instead of B. So.
Okay. So what is the question?
What is your intake on abolition of Intellectual Property Appellate Tribunal?
Abolition of intellectual property appellate tribunal. See, whether appellate tribunal is there or not, the problem is we need an effective adjudication of intellectual property rights disputes. Now it is a policy matter for the state whether to do it through the appellate tribunals or for some other tribunal. That doesn't matter. The thing is that we must have people who are well conversant, well aware and well educated, well sensitized about the subject who decide the dispute. Be it appellate tribunal, be it high court, be it any other adjudicatory body, we need people who are well versed. It is the eternal debate between the specialists and the generalists. But then litigation in intellectual property must be handled by people who are well conversant with the field or in the field.
Thank you, sir. Thank you. Now over to our head of the department, Dr. Monolita Kundudas, madam. Yes, ma'am. Please come to the platform.
Thank you, Indranath sir. Thank you, sir, for a detailed narrative of international IPR regime and elaborating on challenges of India with the basic understanding of IPR significance, international protection, national protection, showing to all participants in this 5-day national FDP the way ahead in this IPR regime. Thank you, sir, for a wonderful session. Thank you so much.
Thank you.
Now,
Nice to see you after a long time. Hope
Thank you, sir.
you are well and everything is
Yes.
well at home.
Yes, sir.
Yes.
Everything is well at
How
home.
old is your daughter? How old is your daughter now?
Sir, now she is 10 years of age.
Wow. So she is going to school in class 5? 5?
Yes, sir. Yes, sir.
Very nice.
Now, thank you, sir. A bit of information to the participants. Today we close our session, and tomorrow is the last day of the 5-day FDP. Our first session is by Dr. Sunita Abhay Jain, of Professor of Christ University, Bangalore, and it starts at 10:45 a.m. And the second session is by Dr. Shashikula Gurupur, Dean and Director, Symbiosis Law School, Pune, and the second session is 1:30 p.m. And thanks to all of you. Stay safe. Thank you all.
Bye.
Thank you.